Hey, how's it going, everybody? Mike Weber here, your Los Angeles real estate broker. And as I shared in my market update video for the Los Angeles County area and South Bay Beach cities yesterday, I wanted to share with you guys this new law that was just passed a couple days ago by the governor of California, Gavin Newsom. It's called the COVID-19 Tenant Relief Act of 2020. And the reason that I wanted to share this with you guys is because it's very, very extreme in terms of what it does to protect tenants. And I think, most people that I'm talking to, they don't even have any idea that this has happened. So there's some very, very serious implications for both tenants as well as landlords related to this law. And so I just wanted to go over some highlights, some important things that I've found, that I've picked out so far in the information that I've gotten. And I just want to be clear up front, this is not intended to be legal advice. So if you're a tenant, you're a landlord, you're having issues, call your real estate attorney. This is simply to point out some of the information that has been shared. And I'm simply going to share that information with you guys to give you an idea of some of the changes that are happening currently in California, and ultimately some of the ways that the government is stepping into the private market and preventing the market from functioning the way it otherwise would. So for better or worse, let's jump in. So I'm going to just review and read some of the things that I highlighted that I thought were important so you guys can get a feel for what's happening. So I'll start out with a brief summary of the law, and then I'll go on to some additional Q&A after that, and some other things that I thought were interesting. So when a tenant has not paid rent for any period between March 1st, 2020 and January 31st, 2021, the COVID-19 Tenant Relief Act of 2020, also being called the Rent Relief Law, will allow most residential tenants to remain in the rental property through January of 2021 as long as the tenant makes a declaration under penalty of perjury that they are unable to pay their rent or meet other financial obligations because of circumstances related to COVID. For rent that comes due between September 1st, 2020 and January 31st, 2021, the tenant is responsible for paying at least 25%. However, that amount need only be paid by January 31st, 2021. Otherwise, the tenant would be at risk of being evicted for non-payment of rent through an unlawful detainer process, but not before February 1st, 2021. So just to summarize that, essentially from September of this year through the end of January next year, the only rent that is due is 25%, and even if a tenant is not paying that rent, it sounds like a landlord cannot pursue eviction all the way until February 1st, 2021. Continuing on, after January 31st, 2021, and with the exception of the 25% of rent owed from September through January, the landlord will not be able to base an unlawful detainer action on a demand for payment of rent that came due during any time between March 1st, 2020 and January 31st, 2021. So basically what that means is that if a tenant stopped paying rent all the way back in March of this year and doesn't pay any rent through September and then only pays 25% of the rent from September to January 31st, even if they pay that 25%, on January 31st, a landlord would not be able to evict that tenant. Pretty crazy, right? So, continuing on. However, the balance of unpaid rent is still owed. The rent relief law permits a claim for the unpaid rent to be brought in small claims court beginning March 1st, 2021, even if the amount at issue would otherwise be more than the small claims court limits. So although you cannot pursue an eviction for that unpaid rent, from March all the way through September, or even the other 75% of the rent from September through January 2021, you'd have to go to small claims court to try to recover, any of the rent that you didn't collect, and the tenant still gets to stay in the property. The rent relief law temporarily requires all residential landlords in California to comply with the just cause eviction procedures of the Tenant Protection Act of 2019 in order to find a tenant guilty of unlawful detainer on or after March 1st, 2020 and before February 1st, 2021. This is the case even when the property would otherwise be exempt under AB 1482. However, an owner of a single-family property or condo can terminate a tenancy when they are in contract to sell the property to a buyer who will take occupancy. So it sounds like what they're saying there is that the law that was passed in 2019, AB 1482, is still going to apply. And in fact, there were some exemptions in that law, and it sounds like they're saying that even those previously exempt landlords are now going to have to comply with that as well. Now, one thing I do want to say is that I have 21 pages of information here, and I'm not going to go over everything with you guys. So obviously, research this thoroughly. Again, talk to your attorney. Make sure you understand this stuff, because I'm just giving you a synopsis and just talking about some of the points that I thought were most important that I wanted to share. So let's jump into some Q&A on this and see kind of how some of these things would apply in different situations, at least as far as what the California Association of Realtors is interpreting this language so far. So if a tenant has not paid rent that came due between March 1st, 2020 and August 31st, 2020, will the landlord be able to evict the tenant on this basis through an unlawful detainer? Generally, no. For most tenants, the law only requires that the tenant fill out a declaration under penalty of perjury stating that they are unable to pay their rent or meet other financial obligations because of decreased income or increased expenses due to the COVID pandemic. So obviously, that means pretty much any tenant is going to, qualify, right, by just simply writing that declaration, whether their expenses went up, their income went down, etc., or at least most tenants would likely qualify. Question number 2. If the tenant has not paid rent that will come due between September 1st, 2020 and January 31st, 2021, will the landlord be able to evict the tenant on this basis through an unlawful detainer? Answer: the tenant will be required to pay 25% of the rent for this period, but only by January 31st, 2021. So next January, the end of January, that's when they have to pay only 25% of that rent. Otherwise, the answer to the question is the same as the answer to the first question. Practically, there is little difference, since even if the rent is due and unpaid for, let's say, the month of November, the landlord would still not be able to obtain a judgment for possession through the unlawful detainer process, since the amount could not actually be demanded until after January 31st, 2021. So basically, if you're a landlord and your tenant stops paying the rent, there's nothing you can do, for the most part, it looks like, until the end of January 31st, 2021, or I should say February 2021. Moving on, how is a landlord going to collect this unpaid rent? The landlord can go to court, including a small claims court, even if the amount of unpaid rent is more than the small claims court limit. However, the landlord may not attempt to recover any of the back rent through small claims court for this period before March 1st, 2021. So basically another 6-7 months before a landlord is going to have the opportunity to try to start collecting through small claims suit any of this back rent that wasn't paid. Now, can the landlord ever collect this rent through an unlawful detainer process even after January 31st, 2021? With the exception of the 25% of the rent, unpaid rent from September 1st, 2020 through January 31st, 2021, the answer is no. To collect unpaid rent for this period, the landlord must follow the procedures as discussed in the rest of this Q&A. In general, rent for this period may only be collected as a personal debt unrelated to the possession of the property. So you cannot get somebody out of your property who stopped paying their rent back in March and never paid any of the rent as long as they ended up paying 25% from September of this year through January of next year. They're in the clear, and you have to try to obtain a personal judgment against them for the debt, but it's not a means or a reason to seek an eviction to get them out of the property. Next question. Is written documentation of the tenant's financial inability to pay the rent required to be provided to the landlord? Only if the tenant is a high-income tenant, otherwise no. When does the rent relief law expire? February 1st, 2025. So what that means and what's going to happen between now and 2025, your guess is as good as mine. But obviously we're going to have to continue looking into this and seeing what changes, as time passes on. Now, there's been a whole bunch of mandates in terms of legal notices and requirements for landlords. And I just want to say that there's pages and pages that discuss these different notices, process for serving them, what the requirements may be, etc. So I'm just going to read a little snip, but just understand that there's a lot more depth of what you need to understand in terms of these notices and what the requirements are. So how many separate legal notices does the rent law create? It creates 2 completely new notices and 4 that require significant modification of the existing notices as follows. The notice to pay rent or quit must be significantly modified. The notice to perform covenant or quit must be significantly modified if using it to demand COVID-19 rental debt. Both of these notices must be modified to include required statutory language. In fact, depending on when the rent being demanded came due, they will each have to be modified in 2 separate versions. Each of the notices may need an additional inclusion of a notice to high-income tenants, a declaration form called Declaration of COVID-19 Related Financial Distress, which must be included with the above notices, and a general notice informing the tenants of their rights under the rent relief law for tenants who are behind on rent for the period between March 1st, 2020 and August 31st, 2020. This notice must be delivered before September 30th, 2020. If a landlord is serving a notice to pay rent or quit before September 30th, 2020, then this general notice may be attached to the notice to pay rent or quit. What if the landlord fails to follow any of the above notice procedures involving a 15-day notice and inclusion of a declaration form? The rent relief law would deem a notice that fails to comply with the above insufficient to support a judgment for unlawful detainer or serve as a basis for a default judgment. So it's going to be tremendously important in as much as the landlord has the ability to recover any sort of rent through this new act that's passed. They understand the notice requirements and they follow them very carefully. Next, can a landlord demand proof of income in order to verify whether a tenant qualifies as high income or not? No. Either the landlord has already had such documentation in their possession before the 15-day notice was served, or they don't. Most likely this information would have been collected, if at all, at the time of the rental application. This law does not authorize a landlord to demand proof of income from the tenant, nor does it require the tenant to provide proof of income for the purposes of determining whether or not the tenant is a high-income tenant. And if the landlord attempted to obtain confidential financial records from a tenant's employer, a government agency, financial institution, or any other source, then that confidential information could not be used as valid proof of income unless it was lawfully obtained by the landlord with the tenant's consent during the tenant screening process. So those were some of the highlights of things that I wanted to share with you guys. Again, there's 21 pages. I probably read maybe a page worth of the content, some of the things that I thought were most important. This is extreme. It's unbelievable the burden that is being placed on landlords right now. And believe me, I understand what it's like to be a tenant. I certainly feel badly for tenants that cannot pay their rent. I totally understand, but there's a lot of pain, and there's going to be a lot more pain on the landlord side because basically, based on this new act, they're between a rock and a hard place. They can't evict, they can't collect any rent, they can't even evict the tenant if they don't pay any rent. Essentially all the way through January 31st. So not every landlord, is a big corporation that owns a ton of properties. You got a lot of small mom and pop people that own property, a lot of people that live off the income that rental property generates for them. So it's really going to be difficult for a lot of different people. Obviously, a lot of multi-unit loans are not government-backed, so they're not going to qualify for the same forbearance that the government-backed loans are currently qualifying for. So it's going to be up to the lender in those cases. The lender might want a balloon payment at the end of 6 months or a year if they grant a forbearance. So there's going to be a lot of hardship on the part of the landlord or the property owner as a result of this new act. So let me know what you guys think in the comments. What are your thoughts? Is this a good thing for California? Is this a bad thing? Is it fair? Is it not fair? I don't know. You guys tell me. If you haven't subscribed, go ahead and do that now. Yeah, and I appreciate you guys watching. Look forward to seeing you on the next video. Thanks so much. Take care.